Let's play a game, shall we? I'll show you some drinks and you tell me if you can legally call them milk.
Here we go. That's milk. That's milk? That's milk, even though it's like almost all water and tastes rubbish. But that's not milk. Or so says the UK Supreme Court in a ruling from February 2026.
So how did all of this end up in the highest court in the UK?
Oatly is a Swedish company that makes oat milk. They wanted to use the phrase post-milk generation on their cartons. Now the rules say that you can't use the word milk to describe something that isn't milk. So far, so good. But what's milk? Well, the law says it has to come from an animal. Oat milk is a blend of oats and water.
Oats, you may have noticed, are not an animal, so a product derived from oats cannot be classed as milk. The dairy farmers of the UK were not happy with Oatly using the term milk to describe their non-milk product, so they sued.
Nobody seemed to suggest that the phrase would actually cause confusion in the supermarket aisles, but them's the rules. You can't say milk about a non-milk product unless you're using it in a clearly descriptive way, like saying, this is not milk. The Supreme Court gave the victory to Big Milk, not Big Oat.
And it's not just the UK law either. Apparently last year the EU Parliament voted to ban the words oat milk and veggie burger from use in advertising. There are some specific products that apparently have such historical significance that we can't stop using dairy names for them even though they don't contain dairy. They're just brushed under the carpet. Think custard creams or cream of chicken soup, neither of which necessarily need to have any dairy in them. Cream eggs even get an honorary mention.
Anyway, my favourite part is the final bit of the decision. The court said that it's okay to use the slogan on t-shirts. In that scenario, it's not being used to label a dairy-free product. Instead, it's being used to describe the dairy-free human inside the shirt, who's more than happy to declare their dairy-free credentials to the world through the medium of corporate-sponsored clothing. So next time you go around sporting an anti-milk slogan on your t-shirt, don't be surprised when nobody offers you ice cream or milkshakes.
Now I know what you're thinking. Doesn't the UK Supreme Court have better things to do with its time than to determine whether oat milk is really milk? Well, yes, you'd think so, wouldn't you? All I can say is that this case is of more interest to baristas than barristers. And if you want to know where consumer protection laws all began, then take a look at the 19th century case of Carlyle and the Carbolic Smokeball Company. I've also made a video about that. Although I dread to think what the judges deciding that case would think of today's saga.